Okay. I hope I am visible. I hope my screen's visible. I hope I'm audible. Can one of you just put it out on the chat box, please? Okay. Thanks. Thanks. All right. Um, okay. Right. Now moving on. Okay. Welcome back, everyone. We were talking about in the previous meeting, we were talking about the introduction to arbitration. I gave you an introduction to arbitration. I also told you why it is important. I told you the kinds of arbitration, and we also spoke about arbitrability of disputes. The last meeting ended before we could get into the arbitration agreement. And we also spoke about a very, very important case, which is known as the Booz Allen and Hamilton versus the SBI Finance, which is also known as the Booz Allen case. It was a Supreme Court case, and it is a very important case in case of arbitrability of disputes. It also defines a lot of definitions, etc. So I request all of you to just go through that particular case or go through a case commentary on that particular case. You type the case out, you'll genuinely find a lot of commentaries and you'll find a lot of um, things. But I request you to take the original copy or find the actual judgment on the case, because that is where you'll actually be able to, figure it out yourself, and that's what is going to be interesting more than reading the case summary. Okay, moving on. In this session, we will be talking about arbitration agreement. We will be talking about forms of arbitration agreement, and we will also be talking about how to draft an effective arbitration agreement. And in the end, I will be I will be giving you your task. So yeah, that's that. So let's start. An arbitration agreement is the raison d'etre of an arbitration proceeding, which is the main reason, or the reason behind an arbitration proceedings, or the thing that needs to be there before an arbitration proceeding can commence. It is only through the arbitration agreement that the parties can submit their issues to be adjudicated by an arbitral tribunal. Now, if you don't have an arbitration agreement, more often than not, no arbitral tribunal will be ready and willing to be taking the case particularly. Um, and an arbitration agreement not only um, engenders an arbitral tribunal, but it also gives shape to it. Therefore, it is crucial to understand the position of arbitration agreement under the statute. Now, since I already mentioned, there were two arbitration acts. One was in 1940, and one is in 1996. Now, the 1940 Act, under the 1940 Act, the arbitration agreement was defined under Section 2A, and it was, I will just read out the definition and then I will give you an explanation on it. It was a written agreement to submit present or future, any future differences to arbitration, whether an arbitrator is named therein or not. Now, this is a very vague definition. There is not much, it just states that it must be a written agreement. Any disputes or differences must be mentioned in the agreement. It must be referred to arbitration, and an arbitrator can be decided even if the name is not mentioned in the arbitration agreement. Now, it is replaced in 1996. And at the moment, in the 1996 Act, Section 7 basically talks about the arbitration agreement. Now, there are one, two, three, four, five clauses in Section 7. I will be reading out the entire clause. Not on Honestly, I'll just be giving you a definition. And if you want me to send you the provision specifically, um, please drop me a text. I will be forwarding you Section 7, or I will just send you the Arbitration and Conciliation Act as a whole, or you can download it as well. Now, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect to defined legal relationship, whether contractual or not. That is basically what the entire Section 7 specifies. That it means that it's an agreement between both the parties, to submit disputes to arbitration which have already happened or which might happen in the future with respect to any legal relationship, whether it is contractual or not. So there are basically four main points you need to keep in mind when you talk about Section 7, Clause 1. 7, Clause 2 says that an arbitration agreement basically can be an arbitration clause in the agreement already existing, or it can be a separate arbitration agreement as a whole. Now, arbitration agreements are usually separate, but arbitration clauses are usually part of the already existing contractual clause. So it's just inserted as a clause in the already existing agreement or contract or any kind of paperwork, basically. Now, clause 3 basically says that the arbitration clause or the arbitration agreement must be in writing. Now, the clause 4 states that an arbitration agreement is in writing if it is contained. Now, there are certain conditions mentioned in Section 7, Clause 4 of the Arbitration and Conciliation Act, which needs to be followed to make an arbitration agreement an arbitration agreement. It basically says that it must be a document, number one. It must be signed by the parties, number two. There must be an exchange of letters, telex, telegrams, or other means of telecommunication which provide the record for agreement. There must be some sort of communication which states that, okay, the agreement has been entered into between both the parties. They can either be letters, there can be notices, there can be telegrams, there can be telexes, there can be fax. Um, and so on and so forth. It basically records that, okay, this agreement is coming into force on this, and this date. Then you have Section 7, Clause 5 basically states that the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and reference to such is made in arbitration part of the contract. Basically, it basically gives you a summary of the entire thing. It says that an arbitration contract any reference in a contract to the arbitration is specifically specified as a separate clause, it's known as the arbitration clause, or you have an arbitration agreement, which is a completely separate document. Although it is part of the whole agreement, it is still a separate document. They are attached as annexures to the contract. Now, in short, giving you a summary, an arbitration agreement is formed when two parties enter into a contract in writing and it must be signed where they state that any disputes arising between them out of that particular contract will be resolved through arbitration. And the arbitration will be without the interference by the court, and it will be with the assistance of a neutral third party known as the arbitrator. Now, the third party is appointed by both the parties mutually, having consent basically having a consensus on the fact that, okay, this person is the arbitrator that we are choosing. Usually it's an odd number of arbitrators that are usually preferred, but you can always, again, if both the parties agree that both the arbitrators are not um partial to one side and one side, then you can have two as well, but usually it's preferred to be 1, 3, 5, 7. Usually there are five on top. There is not, at least in my opinion, the number of arbitrators has not gone up until 7 as of now. Um, so yeah, so the arbitrator acts as a judge whose decision would be binding upon the parties, and the arbitration proceedings end with an arbitral award, which is passed by the arbitrator, which acts as a judgment, and it is binding on the parties unless the parties agree to go on appeal. Now, if the parties agree to go on an appeal, they need to, if one party wants the arbitral award to stay, they need to file a stay application. Now, if the other party wants it to be quashed, they need to be filing a separate application for that, and whichever the court feels that is valid. Depending on that, if the court stays the arbitral award will be will be continuing until a judgment is passed to stop it or not. Now, if the arbitral award is quashed, the arbitral award is not in force until the judgment, and if the judgment states that the arbitral award is still remains quashed or still remains not in force, it will be going ahead. Now, the arbitral award can only be appealed in the High Court. Any court of a lower ranking than the High Court, will not accept any disputes on the basis of arbitration. Any disputes that have come to them after the arbitral award is not accepted by a court lower than the ranking of the High Court. Now, in the 1996 Act, in Section 8 specifically states that after taking cognizance of a valid arbitration agreement, the court shall abstain from dwelling into the merits and disputes and refer the parties directly to arbitration. So Section 8 basically says that if there's an arbitration agreement or an arbitration clause already existing between the two parties, to refer a certain dispute to arbitration, the court will not even try to dwell into that, and they'll just say that, okay, since you have an arbitration clause, or you have an arbitration agreement, please refer this matter to arbitration. So you have to go through the arbitration proceedings, and only then, if you're not satisfied with the award or if you're not happy with the award which is passed by the arbitrator, can you approach the High Court for, a different remedy, or you can file whatever needs to be filed. Now, an arbitration agreement once made cannot be deferred, cannot be deterred when a dispute arises. There's a particular case that I would be referencing here. I will be mentioning that in the PPT later on. I think I forgot to mention that. Um, in Ravi Prakash Goel versus Chandra Prakash Goel, the Supreme Court basically held that where there's an arbitration agreement present and applicable, the parties cannot take recourse to the civil court without first undergoing arbitration. Now, it is mandatory for the courts under Section 8 of the 1996 Act to refer the parties to arbitration where there's an applicable arbitration agreement. Basically, what I stated has already been stated in the Ravi Prakash Goel case, which states that if there's an arbitration agreement or an arbitration clause already existing, the parties cannot approach civil courts to adjudicate the dispute unless they have already gone through the arbitration proceedings and are then approaching the High Court. Um, so if there's a valid applicable arbitration agreement, the parties must go through the arbitration first, and then they must come to the courts for recourse, or to reverse the decision, or to keep it, or to stay the decision, or whatever. Moving on, you have certain forms of arbitration agreement. A fundamental requirement under Section 7 is that the arbitration agreement shall be in writing. Now, besides that, Section 7 also grants liberty to the parties to form an agreement in multiple ways. Now, there are four kinds of ways, as of what I know, that an arbitration agreement can be entered into. First one I've already mentioned, that it can be a separate arbitration agreement. Second one also I've already told you that it's an arbitration clause, or it's a separate clause in the particular contract. Now, then you have incorporation by reference. An arbitration clause contained in a separate contract can also be incorporated in a contract being drafted. As per Section 7, Clause 5, any reference to a document containing an arbitration clause shall also be construed as an arbitration agreement, provided that the reference is made with the intention to make the arbitration clause part of the contract. Now, again, there are many cases basically which talk about incorporation by reference. So, if you reference a particular document stating that, okay, there is arbitration, if the court permits that that particular reference can be used in this particular instance also, and can refer the disputes to arbitration. Now, it can be, again, it's on the discretion of the particular court if they refer the dispute to arbitration or not. But usually, more often than not, to reduce the burden of the particular court, they usually end up referring it to arbitration. Now, then you have by communication. According to Section 7, Clause B, an arbitration agreement can also be inferred from the exchange of letters, telegrams, or other means of telecommunication, which provides a record for agreement between the parties. Now, in case there are two parties, party A and B, they don't have an agreement, or they don't have a clause, or they cannot incorporate it through any other form of contract. What basically by communication, or the form of arbitration agreement by communication, what it basically states is that party A and party B, for example, there are two parties, party A and party B. Party A wants to refer the dispute to arbitration. It sends a notice, or it sends some kind of communication to party B that, okay, hey, I think this part, Ilya, please stop touching your screen. Instead of going to the court to resolve this particular dispute, why don't we as a whole just refer the dispute to arbitration? This is communicated by party A to party B. Party B says, okay, and it communicates the same to party A. So this is basically, and when both agree, that particular communication as a whole can be referred to an ad hoc arbitration. And the ad hoc arbitration basically can, have the whole arbitration proceedings begin and all of that with the consent of both the parties. Now, so even though the 1996 Act has left the field open for a plethora of ways to form an arbitration agreement, it is always recommended as a standard practice to choose to have an arbitration clause in a contract itself or an arbitration agreement separately. So, as I already said, an arbitration agreement or an arbitration clause is the most valid form of arbitration agreement. Some arbitral tribunal might not take others into consideration. So, keeping that in mind, it's usually preferred that the companies or whoever is entering into a contract have an arbitration clause or have an arbitration agreement as a whole. So, moving on, drafting of the arbitration agreement. Now, the Supreme Court in cases of Jagdish Chandar versus Ramesh Chandar and KK Modi versus KN Modi directly tackled the question of what constitutes a valid arbitration agreement. Now, the Honorable Court arrived at a list of principles that should be incorporated in an arbitration agreement. Now, those principles are as follows: that the agreement must be in writing, the parties shall agree to refer any disputes, present or future, arising out of a contract to a private tribunal. The private tribunal should be empowered to adjudicate upon the dispute. Again, there are certain about eight of those points. But when you're drafting an arbitration agreement, the points on the screen are what you need to be keeping in mind. First is that the seat and venue of the arbitration must be mentioned. The procedure for appointing an arbitrator must be mentioned. The language of the arbitration must be mentioned. And how many arbitrators and the qualifications of those arbitrators must be mentioned. The kind of arbitration that you're going to be followed needs to be mentioned. That is, sorry, sorry about that. The kind of arbitration also needs to be mentioned. That is an ad hoc arbitration or an institutional arbitration. The governing law, that is, which kind of law is going to be followed, that's the Arbitration and Conciliation Act or the Ancestral Model Law, that also needs to be mentioned. The name and address of the arbitral institution also needs to be mentioned. The name of the parties, the address of the parties, signatures of the parties, and you need to have two witnesses to that agreement. It's a general principle that all agreements must have witnesses, and usually the witnesses are two in number. So that must also be kept in mind. I request all of you to make a note of that. There must be two witnesses, and this must be signed as well as stamped by in case there are two companies agreeing to come into a contract, and any company, as we already know, must have a sign and seal that needs to be already agreed to upon by the whole company. So you need to have a stamp and sign and seal of the company, both the companies basically. So that must be kept in mind. So here we are, we come to the fag end of the entire session. I will be handing out your task. So this is the task basically. Now there is, okay, the NHAI and the contractor have basically entered into an agreement to construct an expressway from Hassan to Chitradurga. The length of the expressway is 60 kilometers and it must be completed in two phases. One is 30 kilometers and they have 1 year contract time for that particular expressway length. And the second phase is again 30 kilometer, which is another year thereon. Now, the dispute resolution basically, there's an arbitration clause is provided. Now, during the first phase of dispute about width of the expressway is an untimely payment by the contractor. Now, I have mentioned all the facts that need to be mentioned. Now you need to draft an arbitration agreement upon the basis of these particular facts. I will be sending you the Word format of this particular thing as well. I need you to draft an arbitration agreement on the basis of these facts. And the arbitral tribunal must consist of one particular arbitrator who's a retired Supreme Court judge. And parties to the parties to the agreement or parties to the any proceeding relating to arbitration will have the MD and chairman of contractor with team of advocate and the NHAI with their advocates basically. So you need to draft an arbitration agreement. I will not be okay. I will not. So the date to submit the um, this particular task would be 25th, 5 p.m. 25th. You have a week. I will be sending you all the material and everything relevant by the end of today. I will not be delaying anything, but I will not be sending you any sample. I would request you to Google it and try finding your own samples. Um, so yeah, one second.